unfold. I'm going to hand over to you both and have a great time for the next 45 minutes.
Thanks, Gary.
Thank you, Gary. Hi, my name's Jasmine Rahman, and I am a tax investigation expert. So I am ex-HMRC. I have over 25 years of experience in this area. And the reason why we've organized this webinar is because we've noticed a lot of queries coming through. There's a lot of focus on furlough claims and bounce back loans. And so Marco and we got talking about this and realized there's a lot of overlap in the issues, and we thought it'd be a good way to cascade and share this information and our expertise with you to be able to help you and the taxpayer better equipped to deal with these kind of queries. So I'll let Marco introduce himself.
Thanks, Jasmine. Yeah, no pressure, Gary. Thanks for the great introduction, Jasmine. Great to be invited along today. Much appreciated. Everybody, thanks for joining us wherever you are in the country. My name is Marco Piacquadio. I'm a partner at FRP Advisory. I head up our Milton Keynes office. And I am a licensed insolvency practitioner for my sins. So, Jasmine mentioned that we do see a fair bit of overlap between tax investigations and the world that we walk in. So it's great to be invited along today, and hopefully we can share the benefit of at least a nugget of our experience and some examples of what we're seeing, and hopefully you find it of interest.
Please, if there's any questions you want to ask us, just put it in the chat box and we will answer them. And we really do like to engage with our audience, so feel free to ask and we'll endeavour to respond to them whenever we can. A lot of the times, actually, we are dealing with the queries as they come up through the webinar, or we have last 15 minutes as well scheduled for any questions you would like to ask us. So we'll go on to share my screen. Okay. So is that okay? Can you guys see the screen?
Perfect.
Yeah, excellent. Okay, so business must now play on in the advent of COVID-19 and the furlough claims that have been made, and the bounce back loans. And we have a good picture of Marco up here playing football, and we put the football theme in. We put the football theme in because, it's really important as well. England's playing, and we, as they say, it's been frequently repeated. We wanted England to bring it home. So so we put the football theme just in respect, really, to what's going on at the moment. So we've already introduced ourselves as well, and our contact details are there, and they will be sent out to you afterwards if you've got any queries. Marco and I are very happy to answer any queries you have, and already a lot of people do. So the content we're touching upon today, as you can see, is furlough claims, HMRC, the interaction between HMRC and furlough claims, tax consequences, fraud, which is a very hot topic. Also, love this, taking the boing out of bounce back loans, director's loan account, and you will see later why that is relevant. And also contentious insolvency, what can happen on the other side if, for example, a large amount has been taken out, furlough claims as well, and as a result of bounce back loans. What happens if the company goes insolvent? What do you do? And Marco is the best person actually to be able to advise you on that. Okay, Marco, if you go over this interesting slide.
Yeah, thanks, Jasmine. Before we get cracking, folks, just probably relevant to kind of catch up with where we are, given that we're almost 18 months post-lockdown. So what this slide's able to do is just give you a quick recap on some of the key things that's happened by way of government support. I think it's almost 18 months, as I mentioned, since the start of the first lockdown, but what we now appear to have is a bit of a perfect storm as we approach the end of this timeline, particularly with regards to furlough coming to an end at September 21. So we're 2 or 3 months away now from I can see Gary waving his hand at me. Gary, everything all right? Yeah, super. So sorry, guys. Yeah, just in regards to a bit of a perfect storm, it's a combination really of furlough coming to an end this September, and also as things stand, looking like winding up petitions are likely to be able to be filed again from the end of September this year. So it's a combination of those things, along with repayment of these COVID support loans, which we'll come on to, deferred VAT. There's also significant other issues for sectors, particularly the construction sector, who have got reverse VAT charge to deal with on top of all of this. So we've had some great support from the government over the last sort of 12, 18 months, but really, you know, when things start to return to normal and balance sheets really have now crystallized this debt that wasn't there before, what happens next?
So Marco's very nicely introduced us to the background of the COVID-19 pandemic and all the schemes and support measures that have been implemented by the government. So initially, the furlough scheme was introduced on the 26th of March 2021 for employees who were on the payroll on 19th of March 2020 or 31st of October 2020. So we know it was initially introduced really to prevent the loss of jobs. And the scheme, it covered about 80% of the wages. Well, it's now been extended until September 2021. And as Marco said, there is like this cliff edge at the end of September 2021. The cost of the scheme has been estimated at 14 billion a month. So that's quite considerable amount. And it's estimated that some 25% of the UK workforce is being supported by furlough. So going to the next, we need to remember that the furlough claim is a grant at the end of the day, and it's being deposited straight into the bank account. The amount that is paid out is separate. I mean, regardless of what happens with the furlough claim, the salary has to be paid to the employee. So we can't have this situation where it's taken as in the payment couldn't be made for whatever reason, because the government will distinguish that this is a grant that you've received, and the salary and the wages is separate. How it interacts is obviously it's a percentage of the amount of the salary, and the calculations is important to that. So I start actually posting and publishing articles on this back in March 2020, and all the way through, even from then, I could see that we're going to have a situation where there's an increase in tax investigations, where they're going to look at the tax position, because, ladies and gents, it's taxable. At the end of the day, it is taxable. It's 20%, and HMRC will be looking to retrieve that amount, as well as making sure it's accurate. And HMRC, the way they process everything is very much process now and check later. An enormous amount of work went through, and they just don't have, even to this day, the resources in place to check everything. So this is another reason why as well we have the fraud hotline, where employees could inform on their employers, and we know there's over 30,000 reports that have been made and still counting, and it's HMRC's duty in order to investigate that. So we have HMRC queries, the furlough claim, where they will assess the furlough claim if the business is not entitled to the grant. And this is actually enshrined in the legislation. These are the two things that are in the tax law. And it says they will assess it if there's a change in circumstances. So I've seen a case where there was an ongoing company, the wages or the employees actually transferred from one company to another company, which HMRC questioned. Or you could have, because the grant has not actually been used to pay the cost, which it was intended to reimburse. So you got the furlough claim, but the reason why was in order to cover and be able to pay your employees, but actually the furlough claim, that amount, maybe you haven't paid them, or you have a situation where the employees have not been paid, and that amount has gone somewhere else. Well, that is basically fraudulent. So HMRC can pursue the overclaimed amount and the tax consequences even if the business has closed or it was not taxed or returned in the accounts. So don't think if you close the company, if you've got a situation like that, or it's just simply not being declared, that HMRC is not going to pursue you, which is why I thought it's really important to have Marco here, because he can explain the consequences on the other side. It's not an easy fix. It's not a case of, okay, let's claim whatever the amount, the grant, the bounce back loans, and close the company. There are consequences that will be pursued. So I put this in because I thought it'd be interesting for you. Sorry about the copy. It was a digital copy at the end of the day, not a hard copy. So this is what I got from one of my clients, and they said, help, HMRC is looking into me, help me out. And in this case, he did actually overclaim, and by like roughly £25,000, he did state that. And this is kind of the letter. You'll get a nudge letter. Maybe there's 3 kind of levels where you get a nudge letter where they're not quite sure. They know something's happened, but they're not quite sure. Or the second one will be where they definitely know something's gone, something is wrong. They've probably checked, the payroll. They probably maybe checked their identity. They in maybe, twice as much, or they've looked at the RTI and it doesn't reflect what should be claimed. So there's discrepancies with the information they have. And remember, HMRC has access to a database, which is called Connect. And on that, there's a huge amount of third-party information. So all they need to do in order to check if any employees actually exist is just go and put the name and address in, and it will pop up, and they will see if it reconciles with the information they have. So this is the kind of letters that a lot of the accountants, agents, and even the taxpayers themselves may receive in regards to the furlough claim, which here, an interesting point is they've given a deadline. You need to pay it back within 30 days, or please note that because we are talking about something that would go in the company accounts, and the tax that is paid on the company accounts is normally due within 9 months and 1 day. So it also mentions that there's no interest to pay, unless you haven't made that payment, the normal corporation tax payment within 9 months and 1 day.
Jasmine, it's a really great example, the HMRC letters there that you've shown us. Just quickly, presumably those letters are being received by both the company and the personally by the director, are they? So are HMRC looking to attach claim to both the company and pursue the director personally if there's any sort of inkling that it might be, fraudulently obtained or overclaimed, for example?
Well, not at this point. They're not going to do it at this point because the furlough claim is going to be in the name of whoever made the claim. So if it's the company or if it's a sole trade. So that's what we need to verify first. So who's the employer? In majority of these kind of cases, the employer is the company, like the example here, which I've taken out all confidential details, is the company. So it will go to whoever put the furlough claim in. The director at this point, it hasn't been addressed. So this is not going to happen because it has to be established first, the behavior, before they can even think about assigning it to the director personally, which leads me very nicely, thank you very much, Marco,
seamless
to the
link.
next slide, where I do say that the company director, apologies for that, you should say director, can be made jointly and severally liable for the amount. And the whole law, the legislation behind this actually came into force on 22nd February 2021. And the reason why I've got PLN in there is just to remind me that personal liability notices can be issued on the back of the additional tax or the penalty in the penalty that is being assigned. And remember, the penalty can be as much as 100%. So that is a key thing to remember in this. So the individual is responsible for the management of a company. When I say that, when they look at the directors, be careful because it may not just be the director, it could be any individual as well who HMRC or even the insolvency services on the other side think, is responsible for the management of a company. And how do they look at that? They look at, are they a director? Are they a shadow director? Or are they directly or indirectly concerned in or take part in the management of the company? So please keep that in mind, that if there are other people who are actually operating the company, they could become personally liable. And I have got cases where shareholders have been issued personal liability notices in that case. So which leads me to the next slide about bounce-back loans, which is more Marco's domain.
Thanks, Jasmine. It's fascinating to listen in regards to furlough, and it's going to be really interesting to see. I think we're kind of at that crux point now, aren't we, where over the next 3 to 6 months, all of that starts to crystallise and we see a bit more from HMRC's side, what they're going to look to do. But of equal significance, if not more so, the bounce back loan. And I think, you know, the title to this slide probably says it all in regards to what I'm seeing and what our sector is apparently seeing at the moment. I think it's best to start with just, you know, the intention of the government with regards to bounce back loans clearly was good. It was clearly with a view to helping SMEs mitigate the financial and economic impact of the lockdowns that were being caused initially by the economic impact of the lockdown as a result of the pandemic, particularly the first lockdown back in March 2020. With the speed that these loans were rolled out, there were some clear headline issues which we, you know, was only becoming too aware of at the moment. Limited due diligence was clearly one of the issues, given the speed at which the government were keen to get these loans out through the banks. And we are seeing cases of loans having been paid where criteria may not have been met. We're seeing many cases of loans where funds have actually subsequently been used for personal gain. And I'm sure you've all got lots of stories about Bob down the pub who may have taken a loan and gone off and bought a car or put an extension on the back of his house. I think what I will say from an insolvency practitioner's perspective is, you know, the majority of the recent inquiries that I've had that do have bounce back loans attached to the company as a debt, we are seeing significant proportion of those having potentially been misused by the directors for personal benefit. So all those stories that you're hearing down the pub, wherever it might be that you're hearing them, there, you know, there's no smoke without fire, as they say. It's also become apparent through some of the conversations that we've been having that there were some wily directors that have taken support bounce back loans, C-bills, with a view to using those funds for capex and potentially even acquisitions, which is really interesting. So you're never going to get cheaper money than the money that's been loaned over the last 12, 18 months through this pandemic. Those really wily directors, some of them have been using it for purposes other than what they were necessarily intended for at the outset. Also seeing cases of multiple bounce back loans through groups of companies. Really interestingly, some of those companies actually dormant, clearly, you know, fraudulently being obtained. And I think all of this was done at the point at which these loans were obtained by directors, where there was an intention to fraudulently go about getting this money. I think in most instances, the belief of the director was, we're going to ultimately strike this company off and we're going to get away with it. Well, thank goodness that's not the case, because the government have since very recently retrospectively changed legislation. So the Coronavirus Ratings Act, which is currently in motion, effectively allows for any company that's been struck off within a period of 3 years, allows for the directors to be investigated and potentially disqualified or action taken against them. So that's a loophole that I know that a lot of people were particularly pleased to sort of see disappear, because it's been abused for far too long as it is. And you know, COVID loans and support has only kind of accelerated that abuse and brought it more to the fore. So just put this in context very quickly, just to finish off on bounce back loans. In terms of the taxpayer, so what's the taxpayer going to feel around the loans that have been put out there? There are 2 million applications for bounce back loans, of which 1.5 were approved, so roughly 75%. Costs of the taxpayer, £45 billion in respect to bounce back loans alone. We hear stories about 80% of those bounce back loans being potentially likely to default. So, you know, it's important that we are looking at these cases properly, and I'm glad to see the recent legislative changes to enable those that are taking the proverbial to be appropriately pursued. What we're also seeing in the sector is that those that were initially thinking about going down the strike-off route with a change of legislation are now seemingly be brought to the door of the insolvency practitioner for things like creditors' voluntary liquidation. So they've got a loan, a bounce-back loan, for example. They've got no ability to repay the loan. Perhaps there was never the intention to do so, but they realise they're going to have to reach a settlement with the appointed liquidator, and they're going to have to be proactive about it. So lots of that going on at the moment, Jasmine. Really, really interesting times for all of us.
I think a lot of us have heard a lot of stories, Marco, a lot of stories, and even like car salesmen who have noticed an increase in purchases of cars. And it's one of the things, this is why I have put this out as well. I mean, this is how bounce back loans should be declared. So if you put money in and the loan was more, and you've taken money out, and you have a credit amount. So if I go through this, so if the loan was more than £10,000 that you've taken out of the company, and you're a shareholder and director, you owe your company more than £10,000 at any time in the year, your company must treat the loan as a benefit in kind. Must deduct the Class 1 national insurance. You must report the loan on a personal self-assessment tax return, and you may have to pay tax on the loan at the official rate of interest. So there's definitely a procedure there of if you have taken more than £10,000 out of the company, which is natural, because any money that is taken out, you have to see it has to be netted off against how much you've actually invested in the company. And the whole point was it was in order to prevent directors from using or abusing the facility in their company to be able to take money out without any consequences whenever they felt like. And the bounce back loan definitely does come into this, and it also relates to the director's loan account. I thought it's important we keep this in here because if we have a situation, for example, where the furlough claim has been taken out of the company, the grant, the funds as funds in the company has been taken out for nefarious reasons, for the personal use of the director, or even anyone connected to the director, or it could be the shareholder even, but definitely non-business. It hasn't been taken out for business purpose. So any transactions of that kind, you must keep a record of any money you borrow from or pay into the company, and this record is known as a director's loan account. If you have withdrawn the bounce back loan and withdrawn funds from the company, then that means you owe money to the company. For a lot of us, as I'm sure a lot of you are accountants and agents here, this is for us basic. But the director loan account actually does cross over to Marco's domain. So, I mean, he will definitely look at this. He will look at the tax consequences. So remember, anything in regards to funds being taken out to fraudulent activity where HMRC will look at that. There's tax consequences to that, where there's a section 455 tax, so which used to be 25% but went up to 32.5%. So if you think the corporation tax, if it increases the profit is 20%, well, the penalties for taking out money and having a credit balance with the director is even more steep at 32.5%. So this debt will then be looked at by the company if it goes insolvent. And a lot of accountants, a lot of people don't tend to know this, but this is one of the issues which Marco will be able to go into in more detail.
Yeah, thanks, Jasmine. That's really interesting. Directors' loan accounts are probably by far and away the most common thing that we see that will cause director the biggest headache should a company go into an insolvency process. I think invariably what normally happens, and we're still trying to put the educational piece out there, is that, you know, if a company's got sufficient reserves, ordinarily you take a dividend. What tends to happen with directors' loan accounts is they'll normally accrue over a period of 12 months, and the intention will be, from the accountant's perspective, to effectively declare a dividend and almost reverse the transaction on the loan account. Well, that's fine when the company's solvent. But what if something happens in the period of those 12 months before you're able to do that? For example, you might have a bad debt that doesn't pay, in which case it has a significant impact on your business. The company goes from a solvent position to an insolvent one. Therefore, you've then got this outstanding director's loan account showing on the balance sheet, and that's something that the liquidator or the administrator is duty bound to pursue for the benefit of creditors. Really, really important point. Contentious insolvency, just very quickly, just anything that crops up as a result of an investigation where there's an element of wrongdoing that ultimately, as a result, has caused a loss to creditors. We do a lot of contentious insolvency work as a firm and as a sector. And it crops up in a variety of different ways, some of which we'll go on to, Jasmine. Thank you. But it's important to know, I think, at the outset, what are the statutory duties of the insolvency practitioner? We are ultimately an officer of the court in our role as an IP, whether it be liquidator or administrator, and we are therefore, duty bound by legislation. Most of these duties are set out in a very prescribed way by the legislation with which we work. But primarily, the main duties of an insolvency practitioner will be to realise the company's assets. Okay, now that will include potential claims against third parties. Importantly, once we've realised those assets, we have the ability to distribute the funds again in a very prescribed order.
When you say claims against third parties, what do you mean by that exactly?
Okay, so just looping back into what we were saying about contentious insolvency, Jasmine, should we go through the books and records and find out that Mr. Joe Bloggs has taken 50k's worth of Bounceback loan, paid it to himself at the detriment of the bank that's lent the money, for example, then that is potentially a claim that we can look to bring, which I will touch on shortly in terms of the powers that we have within our legislation, claims against that director as a third party with a view to swelling the estate for creditors. Okay. Ultimately, that goes hand in hand with the rest of our statutory duties, which primarily will focus on investigating the books and records of the company and submitting a report to the insolvency service within a few months of our appointment. And the insolvency service will then have a look at the potential for director disqualification, for example, and ultimately decide whether or not Mr. or Mrs. Director is deemed to be, a risk to the general public should they be allowed to continue to act as a director going forward. Just worth saying, because I know there are a lot of accountants and lawyers on this webinar, that there are certain powers afforded to the insolvency practitioner within the Act as well, which actually enable, should it be required, an order to be made for the delivery of certain records. So if you're an accountant or a lawyer acting for a company historically and you hold vital information that might help the insolvency practitioner in pursuing a claim against a third party, you can actually be sought to deliver up that information as well. So it's really important to know, whilst you in your capacity as professional advisor may have done nothing wrong, if you're aware or holding any information in regards to the director's previous conduct, please note that we will be asking you for those records and you do have a duty to deliver them up. Worst case scenario, you can see some very clear points. I mentioned director disqualification, Jasmine, Gary, 2 to 15 years. So, the higher end of that scale for the more serious wrongdoing, misconduct, possible prosecution. So the remedies available are civil and criminal, depending on the extent of what's happened.
Actually, Marco, what I would like to ask is, because this is something that I come across with accountants and company directors. So initially, the director is really the one who gets in contact with you, because the company is not a live person at the end of the day. Mm-hmm. So that it's the director, they would view it as in they're the ones who's engaged your services on behalf of the company. But then we can see there's this issue where they feel that they've come to you to provide a service, and then ultimately you can come after them for any overdrawn director's loan account, which is seen as a debt that you have to look into. So, I mean, how do you marry that up? Because really they're the ones who you have to attract as your client, right? But
that's a fascinating sort of question, Jasmine. Absolutely. I take an approach that I play things with straight back from the outset. So as an insolvency practitioner that's first sought in regards to a director that needs advice on behalf of the company, it's very important that the insolvency practitioner explains the various hats that he or she will be wearing as part of the process. So prior to the appointment, clearly the insolvency practitioner's role is to give advice to the company in regards to the company's options. I think it's important, Jasmine, just to bear in mind, in line with the question that you're asking, should the director choose not to take the advice, not to voluntarily sort of be proactive in taking steps to place the company into an insolvency process, then there are potentially significant ramifications for that director in either continuing to trade. Potentially, we mentioned the winding up petition route for creditors as well. So often in the event that a director is not proactive in seeking advice and taking steps to do something themselves, ultimately it will only probably lead to the same result, albeit it might be the government equivalent of myself that's looking at the liquidation, for example, should a company end up being wound up by a creditor. So I think in dealing with the question at hand, yes, it's quite a difficult set of circumstances that we're often dropped into, normally by an accountant or a lawyer as the referring party, who has a client that's got a company that is in financial difficulty, or there might be, if the company enters into an insolvency process, a knock-on consequence for the director. I think the best way to deal with it is to play things with a straight back from the outset, explain that the advice initially is being presented to the company in regards to the board of directors' options for the company, and ultimately just be clear from the outset the statutory duty of the IP once appointed, and the duty to realise assets, investigate, and ultimately do what they can for the creditors to return as much as possible. And that will include, potentially pursuing third parties should there be an element of wrongdoing that's been done. I think the biggest thing that you need to be wary of as a director is probably going to speak to an insolvency practitioner who will tell you what you want to hear for the purpose of simply seeking to get that appointment. And ultimately, the other side of the appointment, the dangerous thing from a director's perspective that might not have heard all of this beforehand, is the first that you might know of it, you get a lawyer's letter saying you owe X amount of money to the company. Please, let me know your proposal for repayment. So I approach it very openly, Jasmine, but it's not easy. I will admit it's not an easy set of circumstances to be dropped into.
And that's exactly the kind of circumstances where I get pulled into on that side of things, because a tax investigation has taken place, and it's impacted the director's loan account. And then we've got this contentious issue afterwards where the director had no clue that the impact of that would be, he would end up having to pay the overdrawn director's loan account. What do you do in cases where a personal liability notice is issued? Do you see that as part of your duties in informing the director, or do you see that as a separate issue because it's personally attached to the director, not to the company?
Brilliant question once again, Jasmine, and it probably goes hand in hand with items such as personal guarantees, for example, which will crystallise in the event of default by the company not being able to make payment, or by the company falling into an insolvency process. It's very, very important as a licensed IP that's potentially giving advice prior to an appointment that there is a record of the fact that you're referring that separate legal advice be taken in regards to those issues. We are dealing with a company matter in the event of it going into liquidation administration, for example. In regards to any personal liability notices or personal guarantee crystallisation, the director need to be recommended to be sought their own legal advice. The two are entirely separate, okay? Albeit one might have a knock-on to the other.
And it relates back because the furlough claims, if anything has been overclaimed, the penalty can be 100% of the tax, which if they find evidence of deliberate behavior, then can be transferred into a personal liability notice, which could come out the other end. And when you've got a situation of a company going insolvent because perhaps they can't pay their tax bill, there's still this other side of it. So, that's really good, Marco, that you would advise, the director, you need to look into this further. But I've come across a lot of situations where the director does not have a clue. He does not have a clue at all, and the insolvency practitioner hasn't even advised them of this situation at all, because it's not in their interest to, from what I understand, because it's not a debt directly relevant to the company. Is that true?
Yeah. What I would say is, in fairness to our sector, we are only able to work with the information that's readily made available to us at the outset. So if I'm not told something by a director, then I will definitely not be able to sort of help them or assist them in terms of both the company's responsibility and who they need to go to speak to for third-party advice. But where the information is made available, and I always suggest to directors at initial meetings or calls, let me know everything, and if all the cards are on the table, we can then at least go into everything with our eyes open, and that would include you guys being aware of the risks should A, B, or C end up being the eventuality. We come on to a really good slide next, don't we, in terms of the commercial factors that an insolvency practitioner will have to consider as part of their role in dealing with an insolvent company where it's been identified. But just quickly, just to go through the antecedent transactions. So we spoke about the investigations and effectively the powers that are afforded to an insolvency practitioner within the insolvency legislation. Two or three of the most common ones that we see, and again, this goes back to my friend down the pub told me it was okay to do it. We'll start off with a preference transaction. Now, preference transaction is a relatively simple transaction for us to review in terms of us being able to show that one creditor has been put into a better position than another creditor, for example. And the most common ones that we would see would be a brother, sister, mother, father, son, daughter being paid ahead of somebody else, for example, that might not be connected. And in fact, the intention there to put that person in a better position where they are connected is actually presumed under the legislation. So those are common things that we see. Also, importantly, if you've got an overdraft facility, for example, and you've personally guaranteed that overdraft facility, be careful where funds are being used to clear down the overdraft facility pre-insolvency, to get yourself as a director out of potentially the consequence of that personal guarantee crystallising. Where it's done so in the ordinary course of business, there might be an argument for the director that's the usual modus operandi. But ultimately, if it's been done some other way, just to put yourself in a better position, that can also be overturned potentially as a preference transaction. Restore repay account. Once a preference transaction is identified, we can either go after the beneficiary of that transaction, i.e. brother, sister, father, daughter, or go after the director. We'll loop back into misfeasance, which is a catch-all. The other most common antecedent transaction that we see, Jasmine, transaction at an undervalue. This is quite a straightforward one to spot again as well. So essentially where typically an asset has been given away as a gift or at significantly less value than market value. So if you start thinking about plant and equipment that might be sold to my best mate, Dave, for £1,000 that had a value of 100,000, for example.
I see that as well. Going concern.
Yes.
Yeah, I see that come up a lot.
Now, again, this goes back to the pre-appointment period that we've spoken about previously. I'm not an agent. I don't value assets, but we do have independent third-party agents who will offer a layer of Teflon coating to the director if for any reason there is a transaction that needs to have that security.
A lot of
blanket.
directors don't realize when you
No.
for example, if you've got a restaurant or some kind of trade or that has plant, has equipment, has machinery, if you simply close it down and open it up under another company, there is a going concern issue, and there is going to be a valuation issue, and so that is going to be asked automatically in any kind of insolvency proceedings. So that's really good that you pointed that out.
Yeah, the best one for the insolvency practitioner is kind of the catch-all. The misfeasance section of the Act, section 212, allows us to pursue directors personally where we can show a breach of fiduciary duty. Okay, that might look like something as simple as not acting in the best interests of creditors, not acting in the ordinary course of business, and not acting in good faith. Those terminologies are quite broad, aren't they, in terms of what we could find in the books and records that might allude to the fact that that's happened. Again, if we are able to challenge successfully a breach of duty under the Act, restore repay account to the company for the position that it would have been in had that transaction not have taken place, all really, really strong powers available to the appointed IP should something have happened pre-appointment that shouldn't have done so.
And again, I've seen that. So where tax investigation has taken place, it's not being challenged, and then extraordinary figures are produced, which then has a knock-on effect on the director's loan account, and then it comes under this. So even the liquidator, has said to me, we can see there's something not quite right about the figures, but we can't quite get to the bottom of how and why. And that's because they haven't understood how the tax investigation has taken place completely unchallenged, and or has been and the figures haven't been maybe disputed or quantified properly. And a lot of times it's very generalized. The figures may be done on a rough percentage where they say, oh, we think we went in on this day, we saw there was 40% of sales on that, 40% cash maybe on that day, and therefore we're going to uplift the sales by 40% over the last 6 years, which is quite extraordinary approach to take, and then which has a detrimental effect on the director's loan account, leaving the director with a huge debt, which it's incumbent on the insolvency practitioner to pursue. And that's where I've been brought in, because they know, even the liquidator knows, there's just something not quite right with this picture. So it's good that you brought that up, definitely. Okay, commercial factors or settlement.
Thanks, Jasmine. So look, if we've been in and had a look at the books and records, and we've identified a transaction that probably shouldn't have taken place, that's caused a detrimental impact on the position of creditors, ultimately it's likely that we're going to start to write to the directors to seek to bring that to their attention, and also seek to look to put right the position. So some of the things that it's important for the directors to understand. Okay, we're not all horrible people. We're not all here to make people bankrupt. We're not all here to take people to court. However, we do have a duty, obviously, to the creditors, that we put right anything that might have happened beforehand that shouldn't have done so. We have some commercial factors that all of us as insolvency practitioners will need to take into account in the event that we are appointed liquidator or administrator and have identified some of these transactions. It's also important to note that we have similar powers if we're trustee in bankruptcy. So, should it be personal insolvency that we're talking about, same principles apply, that if something happens untoward that shouldn't have done so, we'll likely be able to come after it. So quickly run through some of the things that I need to think about in those circumstances. The cost of pursuit of the claim versus the benefit to creditors. If somebody's taken £50,000 out by way of Bounceback loan, for example, how much is it going to cost me if that person does not, respond to my initial correspondence to go legal? And what will be the net benefit to creditors should I have to spend with my team X amount of hours at X amount of cost, along with legal teams in recovering? There's no point pursuing a claim worth 50k if it's going to cost 80k, for example, in professional fees. It will have no net benefits to creditors. My investigations will need to be proportionate in regards to the circumstances. Again, you're not trying, I think the terminology is, don't try and crack is it a peanut with a sledgehammer or something like this? We have to be proportionate in the investigations that we undertake, make sure that they're appropriate. Often directors will be of the belief that if they leave nothing in the company, there's no possible way that the appointed insolvency practitioner will have any funds with which to pursue them. Well, I'm pleased to say that's not the case. The reason being that there's been a relative explosion in the litigation funding world within the insolvency sector of late. And whilst this funding can be expensive to insolvency practitioners, it's a market that's become more and more competitive recently. So therefore, if we have no assets within the company with which to pay lawyers, for example, we can either look at litigation funding as an option, or we can ask the lawyer. Many of the times that we do, it will be lawyers that we have existing relationships with that will look at a case initially and be happy to go down a CFA route, for example. Obviously, we'll take relevant legal and counsel opinion on the strength of the claim before we pursue it to make sure we've got a reasonable prospect of being successful. We'll have to most importantly decide as well at the outset, is this director worth powder and shot, which is a saying that I love. So if I pursue this guy for £500,000, but he doesn't own any property, lives in a rented accommodation, drives a clapped out old car, for example, what benefit do I have from even being awarded a judgment for that amount if I can't actually crystallise any cash to come back to creditors? Just finally, we do also have the ability to sell claims within the legislation, albeit it must be said that would be a relatively kind of last resort type scenario in my personal experience. But really important for those that are wanting to know what do we have to take into account, what are the commercial factors that we do take into account in those circumstances. That's a pretty good summary for you guys.
I think it comes down to why should a director engage you at the end of the day. And I think I definitely have come across a case where the insolvency practitioner of their own choice had been removed by HMRC.
Yeah, absolutely.
And HMRC put their own insolvency practitioner instead, which has led to a bit of a nightmare of a situation because he is not receptive to anything that the director is putting across, and he's not considering anything. So it's led to a very inflexible position. So I would say it's best to engage your own insolvency practitioner rather than get the creditor to engage it on not on your behalf, but on their behalf. It makes sense to.
Well, Jasmine, it's important to say we've all got a license hanging on the wall, wherever it might be, or for some people at the bottom of a box somewhere, that we've all worked very hard for over the years. It is not in my mindset to put that license at risk for love nor money. I'm not going to do anything silly, but that's not to say that I won't be able to take a commercial approach, as long as it's justifiable to creditors as to why you've reached a settlement that you have. And we work regularly with the likes of HMRC, example, where all of these kind of factors are taken into account. I think hopefully the days of a director appointing friendly IPs are gone. We have within the legislation, as you point out, the ability to replace liquidators. Ultimately, again, I'll go back to the point, if the director's not being proactive to voluntarily go down a route, it's likely that one of the creditors is subsequently going to force them down that route anyway. So be proactive, go and take the proper advice, have a commercial and open discussion about what, if anything's gone on, and try to make the best of a bad situation for all of the stakeholders.
Okay, leading to, do we talk about, we've just discussed that, isn't it? The HMRC position very nicely.
Yes, again, often people are asking us what we're seeing with regards to the revenue at the moment. It's very quickly, because the position is always changing, but in a post-COVID world, to those that are genuine, I think, I don't know what you're seeing, Jasmine, but there does appear to be a willingness from the revenue to be as helpful as possible. But that's not to say that the same rules that haven't always applied don't still apply. So if there's been misuse, there's been avoidance, there's been fraud, quite rightly so, HMRC, I think, are going to want to continue to take the stance that they have done always, insofar as it's not acceptable and we're looking to stamp it out. We briefly mentioned the point that I discussed with HMRC, the commercial factors, which are on the screen at the moment. But, recent legislative changes around the ability to investigate directors, for example, where companies have been struck off, it all points to the fact that, yes, we will be helpful, but not where people have been taking the proverbial, again, as we mentioned earlier.
I think everyone will probably support you on that. I mean, these grants and support schemes have been put in place to help businesses and help people out of this situation. It hasn't been put in place in order to act fraudulently at the expense of the taxpayer. So I think a lot of us would agree with HMRC in taking this stern approach in regards to any fraudulent claims on furlough and bounceback loans. Although HMRC has no jurisdiction over the bounceback loan, there's nothing enshrined in legislation for them to pursue it, only if there's a tax consequence as a result. So maybe if, like, the balance sheet, there's a hole in there and it doesn't make sense, which will affect the profit, only in an indirect way would that have an impact, because bounceback loans at the end of the day are not taxable.
Yeah, quite. It's interesting to see how different departments within the government, are treating things differently. So you mentioned the change to the legislation on companies being struck off for bouncebacks. I'll be really interested, Jasmine, to see how furlough investigations kind of crystallise the balance sheet debt going forward due to the revenue, and hopefully we'll have a chance to get some real life examples out on the next webinar at some point, just to give some more examples. But just finally on that, you'll know as well as I do, HMRC and the appointed liquidator will work with directors in seeking sort of tripartite type agreements. So where there's a loan or a balance, I should say, due to the revenue, both by the company, and there's also an element of personal liability notice risk attached to the director, We will work as a triangle, if you like, or at least have an open discussion about the possibility of reaching tripartite agreement. Apart from the example you just gave, Jasmine, obviously.
See, well, Marco and I, we had a discussion about this yesterday, and I call it the Bermuda Triangle because everything gets lost in it between the director, the accountant, and the insolvency practitioner. And in this the Bermuda Triangle, you get the PLNs in there, the personal liability notice, where no one has a clue what to do with them. So it's not in the jurisdiction of the insolvency practitioner. The accountant thinks, oh, hang on, the company is with the practitioner. We can't do anything about it. And then the director's being told that we can't do anything about this either, because it's all going to my agent and it's all going to the insolvency practitioner. And that's why I say that it's a Bermuda Triangle, because it gets lost in it. And then a couple of years later on, when HMRC takes the director down the bankruptcy route, perhaps, and I get a knock on my door. In fact, my first article was on this issue, because everyone seems to be shifting the responsibility around. So even though it's addressed to the director, but the director goes to his professional agent, accountant, who says, oh, hang on, the practitioner knows about it. And as we know, and as you've just said, you're not actually, if they don't tell you, you don't know about the situation.
Yeah, it's interesting. There's been an explosion, off the back of the avoidance claims that were initially sold years ago. Some of those claims, depending on when the schemes were entered into, will create personal liability notices. At the same time, if the company's insolvent, goes into liquidation, it's likely going to be pursued by the liquidator as a breach of duty. So, a director won't want to settle a liquidator's claim for misfeasance to still only then have the personal liability issue hanging over his head. So it's in those circumstances, Jasmine, that we work as a triangle, if you like, to try and bring a settlement on a tripartite basis that will at least allow the director to draw a line under the whole thing. But yeah, really interesting times, and who knows, maybe we'll get somebody on from the revenue at some point in the future, Jasmine.
We may do. We did bring someone in last time, so on the statutory review and alternative dispute resolution. So someone from HMRC did come on board, and maybe in regards to fraud investigation, especially the furlough claims and so on, that would be good. And also the input on the other side, because I see it's quite inflexible. A lot of the times, because the HMRC representative in the insolvency process is not an actual caseworker. So they're just getting the notes handed onto them, and they're just taking the facts from whatever has been handed over.
That's really interesting. That's a really interesting take, because, often the view from the IP's end is certainly in my personal experience, is quite the opposite. So that the level of understanding within the revenue, from what I see around the circumstances of insolvency and the tax implication from whatever's gone on beforehand, is good. So there's clearly a grey area there.
There is, I think, because the issues, remember, the kind of issues I'm getting are all contentious. So I'm not seeing it. My view is going to be a bit distorted, because they're all concerning contentious tax issues that have come to me, and where they feel HMRC has been unreasonable, or not as reasonable as they could be. It could be the other way, because even when I look at it, I think HMRC has a case here. But maybe not to the extent that HMRC is saying. So for me, it's interesting you're seeing that other side, because I'm getting this perspective. In fact, I find it more easier if I go back to the caseworker, rather than go through that route. I go back to the caseworker and talk to them directly in this kind of situation, because they understand why they produce the figures they have, and they will understand why I will put forward an argument and say, well, I think this, and this, and they will consider it. So and the caseworker is, because they've got that understanding, they will consider those points. A lot of the times it's simply been because no one has actually engaged with HMRC.
Yeah, and
that has been the issue.
Yeah, we see all sorts of burying heads in sand in our game, so I can quite imagine you see the same as well. I think just quickly, there's a nice slide there with regards to FRP and what we do as a firm. I'm sure most of you out there will have heard of us, but if you've not done, then these are our 5 pillar services. So along with the restructuring advisory, we also do corporate finance, debt advisory, pensions and forensic services. they all tally quite nicely in with each other. But if you need anything, if you've got a client that needs anything, your contact details are at the start of the webinar. Please do feel free to either get in touch with myself or Jasmine in the first instance.
Okay, and you know who I am. So I'm that person when you get that brown envelope with that dreaded HMRC stamp and you're not quite sure what to do, that's where we step in. And so we deal with all types of tax investigations, all tax heads. And also, you know, we're happy to step in where, you know, accountants need like help with appeals and other kind of one-off kind of situations. So, but I do try and kind of bridge that gap where there's not enough, maybe it's not cost effective to engage someone with an expert in that area, but you need some advice. So I do on my LinkedIn account do share that information to make it easier on agents to deal with it, and also to deal with it and provide a good service to their clients, which is what we all want. So I know I can see straight away Tony is here because he's asked Tony Margaritelli is here, and he's asked me an awkward question. Thank you, Tony. Should accountants consider the money laundering regulations when they encounter furlough or BBL abuse? So in regards to any abuse that's taken on, I think if there's been any fraudulent activity, because normally it's anti-money laundering is precisely that, to do with an illegitimate source of money being brought in. I think that's addressing a different issue in regards to that, because we know where the money has come in, if it's furlough or bounceback loans, if you think about it. So I think the correct probably authority would really be in regards, it would probably in regards to furloughs, definitely HMRC, because we know where the money's come from in respect to this. So I will check on that further. So that probably content for another post later on. But I saw this awkward question being asked on LinkedIn, Tony. Did you get it from there, I wonder? But I will definitely look into that. And but my instinct would be no, I don't think not really, because we know where the money has come from, and it's not coming from criminal proceeds at the end of the day.
Jasmine, just to put an insolvency angle on the bounce back loan issue, if there has been misuse, we are obligated as the insolvency profession, appointed insolvency practitioners, to notify the insolvency service. So slightly sits outside of the AML question that Tony's just asked, but there is an obligation on the appointed IP to report any misuse in regards to bounce back loans, which hopefully covers off the slightly different angle.
Okay, there's some more questions I can see here. If someone else, I've seen this, I've actually seen this quite a few times. If someone else has applied for bounce back loan in your name, what can you do? So I gather it's where it's probably, you know, not done with your permission. So I've come across situations where a director has actually rung me up and said, Jasmine, I've got some dormant companies, but apparently someone's been submitting furlough claims on behalf of the dormant company. So it looks like someone's going through Company House, looking at where all the live companies are, but dormant, and putting claims in. And I think also bounce back loans, though if that happens, then obviously you need to inform the correct authorities. Like with the bounce back loans, it will either who would know, it'd be the NCA, isn't it, National Criminal Agency, in regards to a bounce back loan, because that's who have been making the arrest. And in regards to the furlough claims, then it will definitely be HMRC in regards to that. So
it's frightening, Jasmine, isn't it, in regards to what fraudsters are up to in this day and age, and you know, just every avenue of possibly defrauding. In this case, as the question is, you know, a helpless individual at the end of it. It's absolutely terrifying, the extent of fraud that's going on out there at the moment.
Actually, over COVID-19 period, scams had increased by 400%.
Wow. Wow, it says it all, doesn't it?
It says it all. So yeah, by 400%. Okay. Another question is, if you have incorrectly claimed furlough, can this lead to more investigations? Yeah, I've had this as well. I had this with the ETA. We've not actually discussed the other program support schemes like Eat Out, Help Out, and SIS, because in this regard we're only talking about kind of from the company perspective. So the SIS is more income tax, and I've already published a guidance in a nutshell how to deal with it. And Eat Out, Help Out at the end of the day is only 13 days in August compared to the impact that the furlough claims are having, which is why we've concentrated on the furlough claims. So if you have incorrectly claimed furlough, I think a disclosure, rather than HMRC coming and knocking on your door, it would be better for you to go to HMRC and declare it. So we have a situation where HMRC has put in, if you don't let us know within 90 days of the date when you put the furlough claim in, then they will deem it as deliberate and concealed that you intentionally disclose the overclaim. And that then leads to the ground of behavior of establishing a deliberate and concealed behavior penalty, which will lead to 100%. So that's how they're going to build their cases up. So already you're going to be on a back foot if you don't go to HMRC, even if you have, if you, and I, in one situation, I have had, a client coming to me and said, yeah, I have overclaimed. I was desperate. I shouldn't have taken the money, but I did. And I need to declare it to HMRC. So I would say, yes, declare it to HMRC, but be careful because it's the way you declare it. Okay, so you need to disclose it, but be aware of the behaviors you demonstrate could lead to a very harsher penalty. So you need to be able to build up the basis of your penalty. So the furlough claim in itself, I see is more clear cut because the accountant and the client, they know if it's incorrect. They know how many employees there are. They know what the rate should be. They should, all of these can be verified quite easily, whether it's a large amount or a small amount. The issue is the penalty at the end of the day. And that's where, you should disclose it because it will lead to penalty being reduced as a consideration of your cooperation. Now, will it lead to further investigations? Again, it really depends on the case. If we're talking about a lesser amount, if it's not cost effective, no, I don't think so. But if we're talking about a larger amount and it's fraudulent, then it will open up to HMRC looking at everything in your tax affairs. Because that's what fraud investigations, that's what happens. So it depends on the actual situation. Under what circumstances you've overclaimed it, is it deliberate, or not, and the quantum. Okay, which leads us nicely to 503. I think we've answered all the questions, and it's been good. I'm glad that you have put those questions. I have someone, I think I still got to go back to Tony just to confirm on that regards, but thank you all for attending. It's really been great to have you on board, and thank you, Marco. I'm going to invite you in the future because I think the Bermuda Triangle definitely needs to be addressed a lot more in the future going forward.
Yeah, it's the first time that I've been asked to explore the Bermuda Triangle in more detail. Jasmine, thanks for having me. It's been great. It's been really great. Thank you.
And Gary, thank you very much.
It's a pleasure.
Are we going to stop going live? What happens? Because we're on YouTube as well, isn't it?
That's right. We're about to stop. So it's been fantastic. For somebody who's in business, we need to know those implications. You've explained it so well. If you've enjoyed today, please share it with others. This will be live. This will go onto Facebook, and we'll send you an email with a recap of what you've seen today. So I'm about to stop recording, and there you go. And we're about to stop going live on Facebook, and that has now stopped. And now it's just us.
I think there's only one thing left to say, Gary, isn't there, in regards to we are 2 hours and 55 minutes away from kickoff. And let's hope England make it to the final.
Yeah.
There you go.
To keep up with the football theme.
We did postpone this webinar when we realised we was going to overlap. We think no one's going to turn up if we held the webinar.
That's great. Should we let everybody get off and go and get ready for the game? Brilliant.
All right.
Thank you, everybody.
Thank you. Bye.
Bye.
That was really good. Very good.
If you want to go, you can go. But do you want to carry on the discussion?
Yeah.
Last time we had the 2-hour webinar, and people kind of flagged in the second half on the they wanted to hold on, but by the time it got 6 o'clock, then I thought, okay, now we need to shorten it to an hour. Thank you very much, Nigel. Nigel just said many thanks to Marco
Nigel.
and Sinara.
Catch up soon.
And Oasis also said VAT return. Is there VAT return submission? Because yeah, that's another reason. Damn it, we should never do it on the 7th.
Yeah.
All the accountants thinking, oh my God, we got to submit the VAT returns. But how many times are we going to postpone it? Maybe we should have postponed it after the football season.
There's never a right day though. There's always something to do, isn't there? Unfortunately.
It's funny.
That was great.
I
Really
think everyone's
enjoyed it.
really excited about the football.
I'm looking forward to presenting this to the world. So thank you
Great.
both very much.
Okay.
So you two.
Powder and shot. I like that too. That was good.
Is he worth powder and shot, or is she worth powder and shot? It's always one of the first. And I'm not going to lie. That's a phrase that I coined from one of my old bosses who used to use it when I started off in the sector.
That's a really
20 years
old-fashioned
ago.
phrase.
Yeah, it is. It is. And he is retired now, bless him, very recently retired. But
Are you going to keep it live and going?
I'm going to try my best, Jasmine. So I'll love you and leave you as well, folks.
You
Great to see you both.
You've both put in so much work to this, and hopefully thousands will watch it in the end, and it will come to some work for you both.
Fingers
Gary,
crossed.
that's just in the middle. Is he doing a high Hitler or something? I was wondering whether. What is he saying?
Checking the mic and that.
Okay, because I was saying, what is he doing? I thought, shall I ignore
I
that?
saw. Yeah,
I didn't mean to put you off. I was like, what the hell's going on? But it was fine. I fixed it.
good.
Right,
Well, guys,